if I want to know whether a customary grant has been made, as somebody has alleged, I just need to go to the customary land secretariat to confirm whether indeed there has been a customary transaction or not. Then a litigation check. In some cases, people will sell lands to you and they will not tell you that there's an injunction on the land or that there's a suit in court. They will simply just sell the land to you. So it's imperative that you do a litigation check to confirm whether indeed that land is free of litigation. Then you have a duty to ask the seller to present their documents of title, judgments, and site plans to you to review. Then you also have to do a search at the relevant authority. In this case, I'm talking about the Office of the Administrator of Stool Lands, to confirm whether ground rent has been paid in full in respect of stool lands. And then property rates, utility bills, etc. If there's a building on the land, you ought to confirm whether property rates and utility bills have also been paid, because these constitute liens. So a lien is when somebody has a charge, and please, I'll keep breaking the words down, because when I say them, I realize that they are technical. So a charge is when somebody has a right to take something of yours because you owe them. That is a charge. So if you don't pay ground rent, it constitutes a charge. If you don't pay property rates, it constitutes a charge. If you don't pay utility bills, it constitutes a charge. And these charges have an interest called an overriding interest. They override all other interests in land. And essentially, you can dispose of the land to a third party. The third party will be enjoying the land, and then the person whose ground rent is owed can come and sell the land because there's a charge on it, whether the land has been sold or not. So it's imperative that these searches are done. Then, of course, the National House of Chiefs, which I've already mentioned, and then the Traditional Council, simply because historically, the stools have not kept good records on land. What happened was that they were using river banks, trees, dams, etc. as boundaries. They never did a site plan nor registered the land. So, assuming these things disappear, these river banks disappear, these trees disappear, then a boundary becomes an issue. Then you have these chiefs, competing or in courts or even at the Traditional Council over who is the rightful owner of the land. So sometimes when you go to the Traditional Council, there are cases before the Traditional Council in respect of whose boundaries are in contention in respect of the relevant land. Then there's a search at the collateral registry. This is an additional search that you can add to the Lands Commission search to confirm whether the land has been mortgaged. When you do a search at the Lands Commission, it also confirms the same thing, whether the land has been mortgaged. But some people take a further step of going to do a registration at the collateral registry if or when there's a mortgage on the land. Next slide, please. Then the people who are authorized to sell land in Ghana are the stool, the family, the states, individuals, and corporate entities. So there are specific people that you can buy land from. The stool. And in the stool, when you get to the stool, you need to deal with the occupants of the stool, the regent, the caretaker. And this must be done with the consent and concurrence of all the principal elders of the stool, all of them. So if you go and you transact with the chief and then you do not get the consent and concurrence of all the principal members, it means that that transaction is an unauthorized transaction. That's what it means. And in some cases, these chiefs, they'll sign a document and then they'll give it to their secretary. Look around and see whether you find two people outside and let them witness the documents. That does not constitute a valid grant, because those two people that the secretary will go and identify are not principal members of the stool. and therefore the transaction can be set aside. Now, in respect of stool land 2, the transaction is void if you do not obtain the consent of the Lands Commission. So every stool land transaction is in the Constitution. You have to obtain the consent and concurrence of Lands Commission. Otherwise, that transaction is void. Then the Traditional Council. This one, if you don't obtain the consent of the Traditional Council, it makes the transaction voidable. The Traditional Council is made up of the paramount chief, the sub-chiefs, and the lesser chiefs. The family or the clan, similarly, you need to transact with the head of family with the consent and concurrence of all the principal members of the family. If you fail to get the consent and concurrence of all these principal members, the transaction is void. Now, you might be asking yourself, how are you able to tell who these principal members are? It's impossible to tell. But this is what I do. I try to get as many people as possible who are elderly. So what happens is you visit the family, you try and get as many elderly people who are members of that family to do a resolution. So if there are 30, get 30 people to do a resolution, appointing only 4 people to sign all the documents in respect of that family transaction. Once these people appoint these 4, then all the documents that you are going to sign must have these 4 or 5 people on there. If it is 2 or 3 too, then all the documents must have these 2 or 3 people signatures on it in order to make it valid. Simply because a member of a family can come and challenge a transaction, and I'm talking about a successor of a person who may have signed the documents. Now, the only defense you have is you have to go to that resolution that I'm talking about and scrutinize it carefully to see whether that person is linked to any of the persons who have signed the resolution. I'm talking about in terms of blood relation. If they are, then it means that that consent has been obtained, and so their successors are bound. The states, if you want to buy state land, you transact with the Lands Commission. And then individuals and corporate entities too, they sell in accordance with their rules and regulations. So you have to note that when you are transacting with an individual, when you're conducting with a corporate entity, rather, the corporate entity ought to sell the land in accordance with its constitution. Otherwise, the transaction can be set aside. Next slide, please. So this is a very interesting aspect of the law, which I just want to throw a little bit of light on. So the law has made a distinction between indigents, citizens, and non-citizens. And this is very interesting. So let's start with a non-citizen. The law says that a non-citizen cannot have a freehold. So a freehold is when you have a perpetual interest in land. You cannot have it. It's not possible. If you have a freehold interest in land as a non-citizen, it will commence from 22nd August 1962, I believe, and it will end after 50 years. And if you take a freehold interest in land as a non-citizen today, it is void. Now, the leasehold interest is limited to 50 years at a time. So just note that when somebody, as a non-citizen or a foreigner, when somebody sells land to you, you can only have 50 years at one time. So don't go and put in 51 years, 52 years, 53 years. 50 years is what the law requires or allows you to have at one time. So it doesn't mean that after the expiration of the 50 years, you cannot have another term of years. No. When does a corporate entity become a non-citizen? So the law has also made provision for corporate entities to become non-citizens or citizens. So the law is that if the foreigners in the company have more than 40%, then the company is a non-citizen, or what we call a foreigner. But if the foreigners have less than 40%, then the company is a Ghanaian. So if you want to transact as a Ghanaian, and you're a foreigner, you can set up a company, but it means that the Ghanaians must have at least 60 or more percent in the company. And then the interesting part is that as a citizen, you don't have an automatic right of renewal. In fact, the law had never made provision for an automatic right of renewal until 2020. So as a non-citizen, if you want a right of renewal, then it has to be expressly stated in your lease. So it will say that you have 50 years with an option to renew for another 20 years or so. So there's no automatic right of renewal for non-citizens. However, when you go to the citizen, it's a completely different story. With a citizen is entitled to an automatic renewal except where the lease is in respect of commercial property or the lease property is for redevelopment. So I have to add something which is not here. This is in respect of government land. If you go and buy government land as a citizen, you have a right of automatic renewal in all cases, except where the property is commercial property or the property is leased for redevelopment. In those scenarios, there is no right of automatic renewal. Now, for the indigene, another interesting part, the rights are different from the citizen and the non-citizen. The indigene, and when I say indigene, I mean a Ghanaian who comes from a particular area. So I am from Kobodumase. My name is Mate-Kole. So I'm an indigene of Kobodumase. Although I have never lived there, my parents are from there. My dad is from there. But I can claim to be an indigene of Kobodumase because they will have an inherent right to this in that area. Entitled to automatic renewal where the lessee has developed the land for residential purposes, a farm of perennial crops, a commercial or industrial property for the same duration as the original lease when the lease expires. This one, it has provided you with a clause, implied clause. It says for the duration as the original lease. So if the original lease is what? 90 years, your automatic renewal is also 90 years. If the original lease is 50 years, the duration you'll be getting on the renewal is also 50 years, which is very interesting. Next slide. So this is also another part where you need a lawyer. Very, very important part where you need a lawyer. It's the preparation of legal documents. So under our law, it is only a legal practitioner that can prepare legal documents. If a legal document is prepared by a non-lawyer, that document can be declared invalid. So the lawyer must endorse that document with his name, address, and a stamp at the front. Even in some cases, when you take your document to the Lands Commission, you don't have that endorsement on it, the document will not be accepted by the Lands Commission. So preparation of legal documents is very important. It ought to be done by a lawyer. Otherwise, it will be set aside. And in fact, the lawyer must be in good standing. A lawyer who has been suspended cannot prepare legal documents. So if you find yourself in court and the other party presents a document and you want to be very critical, you can even go and check the Ghana Bar Association to find out whether the person is in good standing. If the person is not, you present it to the court and let the court know that, look, this document is not valid for the following reasons. This is a very critical point. Now, with the execution of documents, like I said, the law prescribes how the documents have to be executed. I already showed you how schools execute documents, how families execute documents. Now let's go to, for instance, infants. An infant cannot execute a document, and therefore this ought to be done by the infant's guardian. An illiterate cannot execute a legal document unless the contents have been unless there's a statement in the signature section which says that the contents of the documents have been read thoroughly to the illiterate and the person seems to understand it, and that is why they have put their mark on it. and many others. Companies also must execute documents in accordance with the Companies Act. So failure to execute documents will make your documents unenforceable. If your documents are not prepared in accordance with law, and when I say in accordance with law, the law says your documents must be in writing. Your documents must be signed by the person who is conveying and witnessed by the person's representative. And in the same vein, if it's a contract and if it's a deed of transfer, similarly, it has to be signed by the transferor and the transferor's witness and the transferee and the transferee's witness. However, there are exceptions where a document which is not in writing can be proper or legal or valid if it's a court judgment. For instance, if you go to court for a court to make a declaration that you are the owner of the land and the court makes that declaration, it's a conveyance in law and it is valid. Next slide. This is my favorite provision in the law. This one, section 121. And this section has saved a lot of people in this country. The purchaser should have full knowledge of any overriding interest. So the ground rents, property rates, utility bills that I mentioned earlier, they are overriding interest. Property and utility rates, as you can see. Adverse processes in law, these are overriding interest. So when we say overriding interest, we are saying that even if you have a land certificate and somebody comes under this provision, that person's interest will override yours. The one that I find most appealing is the rights of person in actual occupation. A person who is in actual occupation cannot be removed simply because you have a land certificate. No. A person in actual occupation has an overriding interest. And before you remove them from the land, you ought to follow due process. There's a procedure that the law provides that you follow in order to remove somebody like that from the land. That is, if the person can even be removed. So, next slide. So the key takeaways are that prior to buying land, you ought to conduct a thorough due diligence. You buy from authorized persons, obtain requisite consents, and register the land. And I mean, based on the issues that I raised, which are that one, people's failure to conduct due diligence is sometimes what makes them lose their lands. People's failure to buy from authorized persons and people's failure to comply with the law. And I also told that there's a need for purchasers to engage the service of lawyers. We devised a way by which all these issues can be addressed. And this system is what we call the escrow arrangement. So the escrow arrangement is in the next slide. Because as lawyers, we identify the problems, but we also have to find solutions. So next slide, please. So this is something which is novel. And when we say escrow, what people understand by escrow, and that is the correct description of escrow, is that you put your money in a bank, maybe let's say CBG. You know, you put your money in CBG or Stanbic, and then you have some instructions with Stanbic. And once those conditions are met, Stanbic will transfer the funds in accordance with those instructions. This is not the arrangement, that's not the kind of arrangement I'm talking about. This is specifically designed to basically address the problems that we have identified. So, first of all, we've identified that, or we've learned that in foreign jurisdictions where there's a little bit less fraud in this arrangement, the surveyor is important because once you've identified the subject matter, which is the land that you're interested in buying, the surveyor has to do a plan of that land, and then we'll use that plan to go and do a search. That is the role of the surveyor. In some cases, some purchasers may be concerned that the land has been overvalued, for instance. In such situations, we need the service of a valuer to advise us on whether we are getting value for money. Then, the building inspector is also very important because in our jurisdiction, we have standards and we have the building code and all of that. But there are cases where people build and they do not follow these standards. Now, if you do not want any trouble and you have a building inspector inspecting your projects from the foundation all the way up to lintel, and then after this has been done, you go and get your certificate of completion for habitation, which means that you can now occupy the property. It reduces your risk, your exposure significantly. So all of these professionals are part of the escrow arrangement. These are trusted professionals, and whatever money has been put in the lawyer's account, which is the lawyer's escrow account, will be used to pay these people for the services rendered. And you are also dealing with, we are also while the money is in there, we are doing the due diligence, we are doing the preparation of legal documents, we are doing the stamping and registration of the documents, so that when everything is done and the property is handed over to you, you have all your documentation without sweat. I mean, that is the idea. And this is not something that we just developed. This is something that we are actually practicing. We've practiced it with a lot of foreigners who have appreciated it. So, I mean, I'm encouraging us as Ghanaians to try this model to see whether it works for us as well. So this is the end of the presentation. What I would simply advise is that if you are buying property in Ghana, you ought to look before you leap. You ought to be vigilant. Deal with every transaction as though you are dealing with a dishonest person. That's how you should approach every transaction. Let the people prove to you, based on the documents, that they are trustworthy. So that is my 2 cents. Thank you.
Thank you so much, Mr. Mate-Kole. So it's time for questions and answers. If you have any questions, please just put up your hand and I'll come to you with a microphone. Can we have a second microphone, please?
So, good afternoon, everyone. Please, you said something in your delivering that if somebody comes to occupy supposedly the land that you have, you cannot just move the person because you have a land title. But what I also want to find out, what if you've also sort of developed the land in a way before the person came? What do you do? Can we still move the person? Or
Hello?
Yeah.
Okay, so as I understand your question, there's somebody in possession of a land, and so Mr. A is in possession of the land. Mr. B has a land certificate. Mr. B wants to remove Mr. A, but your basis for the removal is that you were in possession before Mr. A came. Is that correct? Okay, so this is a scenario. It's a good scenario. I like this problem question. Now, the question that I'll ask myself is, how were you dispossessed in the first place? When I say dispossessed, I mean, if you had built on the land, Mr. A had built on the land, and then, Mr. B had built on the land, and then he left the land to go for a land certificate, and when he came back, Mr. A had taken over. How did that work out? Do you get me? Dispossessing means somebody has removed you from there. So how were they able to remove you from there in the first place? That's the question. Because it's very important. That fact is very important.
Hello. Yeah. What I'm trying to find out here is that, say, Mr. B has the land already, he has land title already.
Yes.
He developed the land and left it. And then, let's say A came along the line to occupy it. B has the land title, one. Two, he has developed the place already in a very small way. Then he left it. Then A came from nowhere, came to secure the place. That's the question I'm trying to.
Yeah, so what I'm saying is that, so how did A come to secure the place? Because if B is developing the land and he has the land title, then there's no way he should allow A to come and take it. You get me? This is why, you see, if there's something called acquiescence, lashes, and what we call adverse possession. If you have land and you have built on it, and you have a land certificate, and you've allowed somebody to come and take it, and the person is developing it, and you are looking on while the person is doing all of this, the law will say that you have slept on your rights. You get me? So that's what I'm saying. It depends on the time period also. If you wait for too long and you have allowed the person to spend so much money, the law will say that you are trying to benefit. It's called unjust enrichment. You are trying to benefit from what the person has expended. Somebody has invested in the land, and now you've seen that, oh, this is looking good, so now you want your land back. That is where the problem is.
Okay, so it means that when you see A developing, you can quickly.
Of course.
Uh-huh.
That you have to even go to the police.
Okay.
Or even if the police do not do anything, it is a record. You get me? You have to take reasonable steps to show that you are opposed to what the person is doing. Because when you go to court, it's about evidence.
So in that case, that means you can move him in that very.
Yes, if you go to court and you go to the police and you go to court, the court will remove him. Even there's an injunction where the court will restrain him from building, and the same injunction will tell him to remove his building materials and even break down the building.
Okay.
The same court injunction, one application, you're asking for these things, and the court will grant it.
Okay. So I get you. Thank you.
Yes.
Good afternoon, everyone, and thanks for the presentation.
Thank you.
I've learned a lot. I don't know if it's a question or I'm adding something. The point on the alienation of the stool land, that constitutional requirement of seeking the consent and concurrence of the Lands Commission, I think it's been held that it need not be contemporaneous, so that you can do that after the sale, so that the Lands Commission cannot say that they've not given consent, so the land cannot be sold. So when it is sold, or after it is sold, you can then go for that consent and the consent from them.
That is correct. That is very correct.
Thank you.
But that is what the court has held. But mind you, the court can itself depart from its own decision. You get me? The fact that don't be, that's what I'm saying, that you need a lawyer. You understand? The lawyer, the court is doing things on a case-by-case basis. It's administering justice on a case-by-case basis. If the law says that you need the consent of Lands Commission before you sell, and then you go and sell, and then later you say you are going to seek consent, it shows bad faith. What I'm saying, do you understand? It shows that it was an afterthought.
Okay, so it was held that they actually said that it is trite law, so that as long as it is not actuated by any fraud, then there's absolutely nothing wrong with it. Unless it is, like you are saying, there's bad faith somewhere, then there would be a problem. But in the absence of that, there wouldn't be any problem at all if you do it after.
Yeah, what I'm saying is that I agree with you, but I wouldn't want to leave that to a judge. You get me? I would advise that you try to do it prior to the sale. I would advise, because
Sure.
I don't want to leave this in the hands of a judge, because the judges too sometimes, it's not.
Unless you are.
Yeah, I'm just saying that don't leave it to the hands of in the hands of a judge. The court has said it. Yes, we've heard, but try and do the right thing. Okay. Yes.
Hello. Yes, thank you very much. So, I would like to know what the law says when it comes to, let's say, buying lands for minors. Let's say I have a child who is, say, 2 years old. I want to buy the land and put it in his or her name at the time of purchase. What does the law say? What is possible and what is not possible? Thank you.
Okay, that's a very good question. I like these questions. So the rule, I'll give you the rule. So the rule is that if you buy land and you put it in the name of a minor, the presumption is that the minor has capacity until it is proven otherwise. Let me see if I can break it down. You see, the law, it doesn't know how old your child is. So you have given the land to your child, Kwame. The law says Kwame has capacity. But if an issue should arise and we go to court, and then me, counsel, I raise an objection and say, no, this contract is, this contract should be set aside because Kwame lacks the capacity to enter the contract. And then I bring the evidence to show that Kwame doesn't have the capacity. It negates that presumption. You get me? It negates that presumption. So you put it in Kwame's name, and then you pray that during that period that Kwame is a minor, nothing happens. However, what you can also do is that you, as his guardian, you can also take it in your name on behalf of Kwame. Yes, you can also be a trustee and make Kwame a beneficiary. You can create a trust document and make him a beneficiary. There are so many ways of doing it. But in your case, if you just leave it in his name, then you have to pray.
Okay, thank you very much for a nice presentation. My name is Kojo Peterson. Yeah, I want you to throw more light on the issue of somebody having slept on his or her right. So, considering the challenges we have with our litigation systems, vis-a-vis line guards and other unbearable situations, to what extent can the issue that is you slept on your right be upheld against the beneficiary to the disadvantage of him or her? I want you to explain it further, and whether it is enshrined in law or it is discretionary by the judge. Thank you.
Okay, this is also a good question. I like the land guard question. So, you see, you ought to understand that in Ghana, the law works. I have had a lot of occasions where clients have come to me and then they will tell me, I don't trust the legal system. The law doesn't work. And then we go to court and then they get a favorable outcome. And they're like, oh, so the law really works? And I said, yes. You see, when you go to court, you don't presume that the judge knows what you are saying. You don't presume anything. You go and you try to show the judge that you have done everything that a reasonable person ought to do in the circumstances. So what is a reasonable? A reasonable person is a third party, somebody who you expect to conduct himself like a rational human being. You understand? Rational human being. You see land guards have come on your land. They are dispossessing you. What do? Me, I think that what I ought to do is, first of all, I have to also try and remove them. I can try and do this myself. And while I'm doing it, I can take pictures. I can also, in addition, go to the police And while you go to the police, as you are reporting at the police station, they will ask you to put down a statement. This statement, eventually, you can apply for it. It will be a document called a police report. So a police report is also evidence to show that you are opposed to what they were doing. The third thing that I will do, if I were in your shoes, is I'll also go to court. I'll go to court and get an order for the court to to restrain them from coming onto the land. In fact, there's a section in the Land Act called Section 12, which makes it a criminal offense for land guards to basically take control of your land. If a land guard prevents you from getting access to your land, that land guard is liable to go to jail for a minimum of 5 years and a maximum of 15 years. Now, the same land guard or anybody who brought the land guard onto the property, if they restrain you or impede you from developing your land, the minimum is 10 years and the maximum is 15 years. And I'm talking about the people who brought the land guard himself, and any other people who are abetted are liable to all of these offenses. And this is codified and it's in our law. So the judges do not even have a discretion. You get me? So if you do not take these steps, and then you go to court and you say, my lord, there were land guards and I couldn't do anything, and that, I mean, it will be difficult. You need to take certain steps before you even go to court.
There's a hand here. Oh, by the way, if you just joined us, this is our seminar on how to protect or what to do to protect your land in Ghana, presented by Emmanuel Mate-Kole Esquire. If you're watching us live on Channel 1 TV, you're welcome. We're taking some questions from our audiences, and there's a hand here.
I'm Prince Grant Bempo. I want to ask that what is meant by litigation check and how is it done? And also, I want to add that in case a buyer defaults in the payment of land, in case a buyer defaults in the payment of land, will his or her money be refunded back to him? Defaultment.
Okay, let me answer the second one first. It's longer. In case the buyer defaults in the payments, will the buyer's money be refunded? You see, that these are all the reasons why you need a lawyer. You get me? Now, before you make any payments, or even if you make any payments at all, you ought to do that. It should be governed by a contract. So you have to ask yourself, what does the contract say in this situation? Because I have had cases where a client came to me, and normally the clients will come to you when they are in trouble. When they are doing their transaction, they don't know lawyers. And then the client comes to me, and the client tells me that he has made payments, and the seller or the developer has failed to deliver. So he wants the property or his money back. And then I go into the contract and I realize that there is nothing on default. There is no provision on default. There is nothing. So the thing is, sometimes the things are so bad that so I still went to court with him. And then the judge asked, Mr. Mate-Kole, are you the one who drafted this agreement? I said, my lady, no. The thing is, in such a situation, the judge is finding it hard to give him what he wants because he has not agreed to a default clause in his agreement. But in the interest of justice, some judges will try. That's why I'm saying that don't always leave, because you see, the thing about law is that law is neither right or wrong. Law is not ethical or unethical. It's not good or bad. It is just law. So if a judge tries to do right, it's possible that it may not be legal. You understand? And that's what the danger in that is. On appeal, you can lose, although you have been wronged. So it's imperative that when you are originating the transaction or you are about to start, from the beginning, you involve a lawyer. Once you have a lawyer, there's a default clause. The default clause says that if you default, your funds will be returned to you, maybe less 5% or whatever, and it is clear. That is what ought to be done. But where there's no default clause and there's nothing in there, what are you expecting the judge to rely on to give you the remedy you seek when you have signed? It's difficult. It's difficult.
All right, I think we can take about 3 more questions. Okay.
Thank you very much for the opportunity. Please, I would like to ask, in the case where you've purchased a land for 21 years, and then you've put up a foundation, and then you have an uncompleted building on it, and then a single room on it. Okay, so you've purchased the land. Are you supposed to pay any monthly dues to the chief or something?
Yeah, that's a good question too.
Okay.
So, but what was the effect? What was the essence of the 21 years?
Because you've purchased it for 21 years, nobody came to claim ownership of the land, and then all of a sudden, this particular year, someone is saying that he is the owner of the land. Though you have a foundation on the land, you have an uncompleted building, you have a single room structure on the building.
Okay.
Like, from nowhere. And then they are saying it's because you've not paid monthly dues to the chief. Like,
Okay.
is there anything like...
I like this question. It raises a lot of legal issues. So let me start with the 21 years. So if you are in possession of land and you are supposed to be paying ground rent and you do not pay ground rent, you ought to know that the consequence of that is that the landlord has a legal right to take back the land. Yes, he has a legal right to take back the land. Well, obviously, and by using a certain procedure. But one of the authors, Kruger, has even argued that he doesn't have to follow a procedure. He can just take back his land. Because you see, it is the highest form of disrespect in land law for you to occupy somebody's property and not pay anything to the person. It means that you are denying the person's title. And denial of title is the gravest sin in the landlord jurisprudence. Because when you deny your grantor's title or you deny the allodial owner's title, the consequence is that you forfeit your enjoyment of the property. So in your case, you have denied the grantor's or the allodial owner's title for 21 years. And the statute of limitation is 12 years. So after 12 years, if you deny your grantor's title openly and they don't do anything about it, you can now claim to be in adverse possession. So if you've denied the title for 12 years, and depending on your status, because right now I have explained to you that we have indigent, non-citizen, citizen. So let's assume that you are an indigent. Then it means that you have crafted another interest for yourself called the usufructory interest. But now, that usufructory interest it has to be recognized by law. So you have to create a document to show that you are a usufructory owner of the property and to register it so that the registration will show that you are a usufructory owner. So that anybody who comes to challenge you, you can show that person that you have carved out this interest for yourself as an indigent. Do you get me? But in this case that you are telling me, you don't have such a document to support you. And another person is also coming to claim ownership of it. Now it depends on what the other person is bringing. Because if what the other person is bringing is stronger than yours, then that person can oust you. Because you don't have any documents to support what you are saying. Do you get me? Yes, please.
So this is the case that you actually have the land documents, and then it's not the chief coming to say that you refuse to pay monthly dues or something. Do you get it? This is someone also coming to claim ownership of a land you have been in possession for 21 years. So it's not the chief saying that because you refuse to pay the monthly dues or something, I'm coming back for my land. This is someone else trying to claim ownership of the land. And then the chief is saying,
Yeah, but what I'm saying is that, you see, if you were atoning tenancy to the chief, you can rely on the strength of the chief's title to fight this person. You get me? But where you are also not obeying the agreement to the chief, and you have more or less become a rebel, and then you have another person coming. Now we need to know, what is that person bringing? We need to know what the person is bringing before we can tell whether the person has a right or not.
So, hello, my name is Solomon White. Just wanted to ask, you've really elaborated on the need for lawyers before you engage in this contract. But what if you have a case where you didn't involve a lawyer in the beginning and you purchased the land, you got the registration and everything, and you are building and someone else comes in with what looks like a certified document as well to the same land? How do you go about such a problem, say? Because we've encountered that problem at Kaswa where our clients had documentation for the land and other people also came in with documentation for the same land. How do you address such a problem?
Yeah, so you see, I told you that the problems you are trying to address are multiple sale of land. You remember when I said it? So the solution is what I presented to you, the escrow. But you see, the thing is, lawyers are not magicians. You know, you cannot create a problem, you've created a problem for sometimes 20, 30, 40 years. And then they'll come to me, young lawyer, please solve this problem for me. And you expect me to solve it for you in 2 years. It's impossible. You know, it's that you ought to know that there are people in this country who have sold the same piece of land to 2, 3, 4, 5 people. And in such a situation, what do? I would sue the chief. I mean, whoever you bought the land from, and then sue the other person who is bringing the document. Either way, if it turns out that that person got their grant earlier than me, then it means that they have priority. So I'll ask the court that they should make an order for the chief to refund my money to me. But if it turns out that I took my grant before the other person, then I have priority. So then I can seek a declaration of title in my favor. So it depends on the facts, really. But it's a problem. Yeah, it's a problem.
Thank you so much, Mr. Mate-Kole. So, Mr. Mate-Kole has a booth here, M&O Law Consult. So please visit him and ask him all your questions after. Okay, Maurice.
Sorry, so this is just a question for him, a quick one. It has to do with, I don't know if you guys ever heard about this thing about squatters' rights in Ghana. If, for example, somebody has a piece of land somewhere that his caretaker has been taking care of the property for about 10, 15 years, and then because of the fact that caretaker, you don't actually pay the caretaker any money. Legally, that caretaker can say that land belongs to him or her. I wanted to ask you your thoughts on that.
Yeah, you see, that's why I told you, I made a point. I said, the law is neither right or wrong. It's just the law. So yes, there are squatters' rights. And if you sleep on your rights and you do not show the squatter that you are the real owner of the property, and 12 years passes, and the squatter is still presenting himself to the whole world as the owner of the property, then it means that squatter has now claimed your interest in the land. That's what we call adverse possession. And even note that you don't even have to wait for 12 years for that to happen. There's also the common law principles of laches, acquiescence, expropriate by conduct, and all other principles. These principles, you don't have to wait for 12 years to exercise these principles. So it's important that if you own land in Ghana, you have to be vigilant. You have to behave like the land belongs to you. You can't allow landlords and people to go and play on the land, and then after 10 years, 12 years, say that the land belongs to you. It will be difficult for you to make a good case.
All right, thank you so much, Mr. Mate-Kole. Thank you so much. So as I said, Mr. Mate-Kole has a booth right here. Please visit the stand and ask him the questions. But he might send you an invoice just for consultation. Thank you so much. Thank you so much. to win some stuff. Hooray, I thought you'd be excited. Please, do you have your numbers here? You picked numbers from the gold key stand. You have your numbers here. Okay, wonderful. So please help me welcome Sata Donzo from Gold Key Properties. She will give us the list and we can know who won what. So we'll have Sata tell us something small before we begin.
Okay, good afternoon, everyone. And thank you for coming to participate in today's event. So as promised earlier, we had gifts for people who visited our booth and then took part in a raffle where numbers were picked. Amongst the prizes include a return ticket to Dubai. We had a weekend stay and some food coupons to vendors who are within our Cantonment City enclave. So Daniela will call out the numbers and then you will come up here to receive the voucher from us. Thank you.
Thank you so much. Okay, so anyone here who has number 6? Did anyone pick a number 6? You did. You have a number 6? Okay, please come show us. Sata, can you confirm this is your number 6? Or is it a 9 turned upside down? It's a 6. Okay, great. It's a 6.
Yes. As I'm trying to say, it's a 9.
Okay, but does someone have number 9?
Let's compare the colors.
Is there a number 9? Please check your numbers. Is there a number 9? No 9. Okay, then you won a 500 CD Nova fuel coupon. Oh, yes. So here's your fuel coupon from Gold Key Properties. Thank you so much. All right, let's move on. Do we have a number 14? 14. See how she demurely got up. 14. She's won a frame from Dashing Opticians. Thank you so much. Thank you so much, Gold Key. Number 4. Do we have a number 4 here? Please check your numbers. Do you have a number 4? Okay, all right. Do we have a number 8? Number 8. Okay, please give it up for her. She has won a 2,000 CD worth voucher for device or accessories with Huawei. Charlie. Thank you so much, Gold Key. Thank you so much. All right, what do we have next? Ultimate prize. Do we have a number 1? Oh! Give it up for her. She's won a trip to Dubai. Courtesy Gold Key Properties. This is real, guys. She's just what she's shaking. Tell her.
I'm shaking.
She's shaking. This is real, guys. A ticket to Dubai. Wow. Please give it up. Give it up. Give it up. Give it up. Thank you so much. Thank you so much. Tell us a few words. How do you feel? How do you feel?
Student, I'm lost. I don't know what to say. I'm grateful. Thank you. To be honest, I don't know what to say. I'm really grateful. I didn't see this coming. Thank you so much.
Thank you so much. What's your name? Sechina. Congratulations, Sechina. I'm sure we'll follow your journey through to Dubai and all. So thank you so much. Please give it up for her one more time. So congratulations to all winners.
So we have some winners who are not here, but we have their contact details. So we'll be contacting anybody who wants something from us to get their prizes. Thank you for participating.
Thank you so much for participating, and thank you so much for staying with us. Please, if you haven't gone around the booth, do so. We're headline sponsored by Gold Key Properties, also by Clifton Homes. Please do well to go around, and thank